Thank you, everybody, for joining me for another in Farrar's Buildings series of webinars. Today's topic is occupiers liability, an overview and review of relevant case law. My name's Tom Bornarton. For those of you that don't know me, I'm a member of the Farrar's Building personal injury team. I joined Farrar's in 2005 as a pupil and have been here ever since. My practice covers all aspects of personal injury, and fortunately, bearing in mind the topic of today's webinar, that obviously includes occupiers liability. The webinar itself is scheduled to fill an hour. It may or may not do so. I haven't yet run through this fully, so I have limited knowledge in terms of how long it's going to last. But if it doesn't take up an hour, then there'll hopefully be some time at the end for me to answer any questions that people may have. You'll all be more than well aware about how these Zoom webinars work. There's a Q&A facility. So if you can either type in a question at the end, or you can type in a question as the webinar goes along. I won't be monitoring that. My plan will be to, with time permitting, answer any questions that people raise during the talk at the end of the talk. So there we are. That's just by way of a brief introduction. In terms of my plan of attack, what I'm going to do is I'm going to set out and consider various aspects of the Occupiers Liability Act 1957 and discuss, when doing so, some of the relevant case law. And that consideration will include a number of features, effectively who owes a duty, who the duty is owed to, and what the standard of that duty is. And that will include special considerations such as children contractors. And of course, I'll then deal with the defence that's enshrined within the Occupiers Liability Act 1957 and 84 for that matter of Volenti non-fit injuria. And then I'll do a similar consideration in relation to the Occupiers Liability Act 1984. Before coming on to the specifics of the Occupiers Liability Act 1957, it's worth just having a quick look at the history to occupiers liability cases generally. Now, occupiers liability cases were a category of common law determined by reference to precedent case law. And what the Occupiers Liability Act 1957 sought to do was to codify the common law relating to lawful visitors. Before the Occupiers Liability Act 1957 was enshrined, there was a number of different types of visitors, each afforded a different standard of care. And I've, on the slide here, got a few examples. So contractors, invitees, licensees, uninvited persons. Obviously, the first three of those examples are what we would now describe as lawful visitors. And the last one is an example of an unlawful visitor. Obviously, with the lawful visitors, the Occupiers Liability Act 1957 will apply. For the last, the Occupiers Liability Act 1984 may apply, but that will certainly be the statute that you will be looking at. So that's just by way of brief examples. And as you'll see as we discuss the matter as we go forward, there's quite a lot of reference to previous cases because both Occupiers Liability Act effectively enshrined what was the common law. And although there are some small areas where the statute effectively is different, a lot of the historic cases are still of relevance. So there we are. That's just by way of a brief history. In terms of the Occupiers Liability Act 1957 itself, what it does, as it says here, is regulates the duty imposed on occupiers to lawful visitors. And it encapsulates within it, as I've already said, all the classes of lawful entries. What it doesn't do is it doesn't change the common law in relation to who is to be considered an occupier. And that's really the starting point, I would suggest, when you have a case involving a potential Occupiers Liability Act. I think it makes sense in any situation is to first of all ask yourself whether or not the proposed defendant is in fact an occupier, and for that matter, whether or not there are other occupiers who are also potentially liable. Now, in terms of asking yourself whether the defendant is an occupier or not, we go to the previous test, which is in the case of Wheaton Lacon, where Lord Justice Denning said effectively that someone's an occupier who exercises an element of control over the premises. So the key there is there has to be an element of control. Wheaton Lacken is also, as you'll all be well aware, authority for the fact that it's not necessary to have exclusive control, and also you can share control, as happened in that particular case. The last bullet point doesn't come from Wheaton Lacken, but it is a feature of occupiers, the test of occupiers, which you should be concerned with or should have in mind anyway, is that legal owners are almost always going to be an occupier. It's difficult actually to envisage a situation where a legal owner won't be an occupier because they will have some element of control. In terms of an example, in case of Harris and Birkenhead, which was a case in 1976, so after the 57 Act, the council, in that case, the council defendant were the legal owners of a property which they never stepped foot in by way of any of their employees. And it was a rundown house, and when the claimant was injured as a result of legally being there, the council were identified as having sufficient control, and so therefore were liable to the claimant for the injuries that were sustained in that particular case. And the control that existed in that case was merely the fact that they could, as a legal owner, take measures to prevent any danger existing, even though they'd never actually been inside the house. So that's the first test, whether or not the defendant or proposed defendant is an occupier and whether or not there are other occupiers present. Then you really need to go on to decide whether or not the person that's been injured is a lawful visitor or not. Now, if they're not a lawful visitor, then the 1984 Act may well provide some cause of action for the claimant, and obviously we'll come on to that in due course. But if they are a lawful visitor, then you're looking at the 1957 Act for what the duty is and what the standard of care is. So what makes up a lawful visitor? Well, it's easiest really to divide it into three types of lawful visitor. So we have those who with express permission to be on the premises. For example, a hotel guest will have express permission to be in a hotel. But of course, as soon as that hotel guest should have checked out, and if that hotel guest should have but hasn't checked out, then they may well be no longer a lawful visitor. And that person, if they stay on in the room, may actually turn into somebody who is trespassing. But that's the first type, someone with express permission to be on the premises. Then there's the second type, which is those with an implied right to be on the premises, where there's been no express permission, but permission is assumed to be unobjectable to the occupier. And that's really the test. So the example I've given on the slide is the Amazon delivery person. So the delivery, and I should say at this point that there are other online delivery companies are available, of course. But in terms of the Amazon delivery person, he or she turns up to deliver the parcel, you have given effectively implied right for that person to be on the premises to make that delivery. What you probably haven't done, though, is given them permission to then go into the back garden and sunbathe in the back of your garden. So what we're doing here, you're beginning to see, I suspect, that whether somebody's a lawful visitor or not is framed by the purpose for which they are on the premises, and whether they're on the premises for that reason or not. And as soon as they step out of that reason, then it's quite likely that they've gone from being a lawful visitor to an unlawful visitor. And the example given by the Court of Appeal quite regularly, or referred to quite regularly in any event, is the dinner party guest who's invited for dinner but not invited to slide down the banisters, should you be lucky enough to have any, that is, of course. In terms of implied permission, and just before we come on to the third type, which is on the slide, in terms of implied permission, it can come into being if the occupiers know that the land is being used by a trespasser, but then does nothing to prevent their activities. It's going to be a question of fact, and obviously a lot will depend on the knowledge of the occupier and the regularity of the trespassing in question. One example which predates the 1957 Act is the case of Lowry and Walker. And in that case, the occupier was a farmer who owned a field, and the field was used regularly as a shortcut to the train station. He knew this, he objected to it, but he did nothing to prevent it. So when a horse, which he put into the field, then attacked the claimant, who was walking across the field to get to the train station using it as a shortcut, as the defendant knew about it, it was held that that person, that was the farmer, was an occupier because the claimant had an implied permission to be there. So it's not always the case that just because somebody objects to the presence of somebody that they are automatically trespassing. There may well be an implied right through effectively use. In terms of the third type of visitor, that type comes from the Act itself and section 2.6, and that covers those with a lawful right to be on the premises, normally pursuant to some form of statute, such as police officers carrying out a warrant or firefighters attending to a fire. That they will have a lawful right enshrined by a statute to be on the premises, and as a result, they will be deemed to be lawful visitors. So that deals with lawful visitors. What about those who aren't lawful visitors? So on the slide here, we have a number of people who would be classified as not a lawful visitor for the purposes of the Occupiers Liability Act 1957. And that's trespassers, invitees who exceed their permission whilst on land, so my sunbathing Amazon delivery driver example, and also people exercising a public or private right of way. Now, the first two, they may well come under the Occupiers Liability Act 1984. And in a lot of the examples, that's exactly what is being discussed. The last one won't come under the Occupiers Liability Act, either 57 or 84, but they might well come under the Highways Act, of course, if the injury occurs on a highway. So that deals with visitors. Moving on to the third starting position, I would say in terms of the Occupiers Liability Act 1957 is what amounts to a premises. Now, obviously, fixed premises are obvious: houses, warehouses, etc. But Section 1.3 of the Act makes it quite clear that it's not just fixed premises or fixed permanent structures that apply. It also applies to movable structures and vessels. So it does apply to scaffolding. It does apply to a ladder. Obviously, the term vessel means it applies to ships. Just a few examples that would come within the term premises for the reason of the Act. And it may well be that you'll see Occupiers Liability Act being pleaded more in employer liability type cases because, of course, of Section 69 of the Enterprise Act removing civil liability for breach of health and safety regulations. And certainly I'm seeing Occupiers Liability Act being pleaded in a more regular fashion in those type of situations. Obviously, it doesn't necessarily need to be done because in employers' liability cases, there will be a duty owed between the employer and the employee. But there'll be other examples where you'll be previously thinking that there wouldn't be a pleading of Occupiers Liability Act, and now there is. So there we are. That's in terms of the premises. I'm just going to move on now to discuss the duty of care that's owed under the Act. And it's very easy to sometimes miss out important parts of the 1957 Act. And I say easy because a lot of people will go straight to Section 2.2, which I'm going to come on to, without actually looking at Section 1 and Section 2.1. And Section 1.1, what that says is an occupier of land owes duties to visitors and trespassers. Well, not trespassers, but that comes within 1984. So I've sort of covered both in this situation. In respect of dangers due to the state of the premises or to things done or omitted to be done on them. And that's, although from the 1957 Act, that's very similar terms in the 1984 Act. In terms of the duty of care and Section 2.1, what that says is an occupied premises owes the same duty, the common duty of care to all his visitors, except insofar as he is free to and does extend, restrict, modify, or exclude his duty to any visitor or visitors by agreement or otherwise. So there is a right to effectively extend or, more importantly, restrict the duty to any visitor. So if you don't have an eye on that, you can go straight to Section 2.2, which sets out the standard of care. which says the common duty of care is the duty to take such care as in all the circumstances of the case is reasonable to see that the visitor will be reasonably safe in using the premises for the purpose for which he is invited or permitted by the occupier to be there. But as I say, an occupier can moderate that duty under section 2.1, if I go back a slide. So for example, parts of a power station may be open to members of the public for educational purposes, for educational visits, such that the occupier has a duty to make sure that there are no tripping hazards along the way for those visitors. But the same power station won't be under duty to make sure that those visitors are safe if they go off the visitor's route into a staff-only section, for example, such as the reactor. So there is an example of how the occupier has restricted or modified the scope of the permission and therefore the scope of the duty of care. So don't go straight to section 2.2. It may be that in cases that you have, it's important to have a look at whether or not section 2.1 or 1 for that matter applies. Also note that section 2.2 relates to keeping the visitor safe for purposes there, not to keep the premises objectively safe. The reason I mention that at this stage is because it's quite easy to look at a premises and just say, well, objectively, it's unsafe. But what you really need to be looking at is the purposes for which the visitor is there. And obviously that's enshrined in section 2.2. For example, a metalworks factory will be far less safe due to molten metal being poured within it than, say, a nursery. Although, having said that, just thinking on my feet, I suspect people won't necessarily agree with that if they've met my children, but there we are. In terms of the duty, going back to the metalworks factory owner, in terms of the duty of the occupier in that situation, it's to take reasonable steps to protect visitors' reasonable safety in visiting a metalworks factory, not in visiting a premises. And it's not, obviously, to stop using it as a metalworks factory. So there we are. Once you've got past whether the duty of care exists, and you move on to the standard of care under section 2.2, one thing that I always flag up is that the standard of care is doubly qualified by way of reasonableness. So it's to take reasonable care to protect someone's reasonable safety. And as I said at the bottom of the slide, I've just flagged up in using the premises for which he is invited. One matter which has been subject to some judicial consideration is whether or not it's the state of the premises that's relevant, or the activities done on them, or whether both can, in different circumstances of different cases, be relevant. Now, I've put up a couple of cases on the slide to just talk about. Tomlinson is a case that you'll all be more than well aware of. House of Lords case in 2003, where an 18-year-old boy jumps into or dives into a shallow pond and suffers a nasty injury as a result. It's by concession made by the claimant's barristers. They ran it along the lines of an Occupiers Liability Act 1984 case. So some of what is said therein is technically obiter, as it doesn't relate, if they're discussing the Occupiers Liability Act 1957, that is, because obviously it doesn't relate to a 57 Act. Nevertheless, persuasive obiter dicta, and as you'll see in a case which we're going to come on to, a lot of it's been adopted by the Court of Appeal in a 57 Act case, so thereby enshrining as ratio. Lord Hoffman gave the leading judgment in Tomlinson, and in true style, he set the scene with comments such as, "Paths now run through woods of silver birch, and in summer bright yellow brimstone butterflies flutter in grassy meadows," which must make you think how this factual evidence came to be before the court. I wonder if that was in a witness statement or whether he just took judicial notice that in this particular park that was what existed. But there we go. Anyway, all we need to know is that this young boy sadly suffered a nasty injury from diving into a shallow pond, and the swimming. The key factor, of course, is that swimming itself was prohibited. So in that case, what happened, as I've said already, the claimant conceded that the 1957 Act didn't apply because he wasn't there on the premises for which he was permitted to be there. And I just want to pause at that stage and just focus on something that Lord Hoffman had difficulty grappling with, because he was asking himself, somewhat rhetorically, whether that was an appropriate concession for the claimant's lawyers to have made. And he had some initial concerns about how this fitted into the claimant's case. And this is what he said in relation to whether the concession that the 57 Act didn't apply or not. This is what he had to say about that. It was, Mr. Tomlinson's complaint is that he should have been prevented or discouraged from going into the water. That is to say, from turning himself into a trespasser. Logically, it can be said that duty must have been owed to him, if at all, while he was still a lawful visitor. Once he had become a trespasser, it could not have meaningful effect. So effectively what he said, what he was grappling with was that Mr. Tomlinson was lawfully allowed to be where he was, and his unlawful act was the diving. And so what Lord Hoffman was having issues with was whether or not the duty owed by the council was actually under the 57 Act to prevent him from doing the unlawful act and effectively to prevent him from becoming the trespasser. Having discussed Lord Justice Longmore's similar concerns which were raised in the Court of Appeal in the same case, and another example case, he went on to come to the conclusion that actually it was a proper concession to have been made. And in doing so, what he said was, I can see no difference between a person who comes upon land without permission and one who, having come with permission, does something which he has not been given permission to do. And it's from this part of the judgment that we can safely say that the Amazon delivery driver example that I gave earlier is trespassing when you start sunbathing in your garden without your permission. Because of course that Amazon delivery driver couldn't do that without coming onto the property with the implied permission first of all. Moving on, what Lord Hoffman and Tomlinson then gave consideration to was the meaning of risk of injury. And he said it meant by reason of any danger due to the state of the premises or to things done or omitted to be done on them. So effectively repeating what is in the 57 and the 84 Act. So that's, as I've said, the terms of section 1.3 of the Occupiers Liability Act 84. It's very similar to the terms of section 1.1 of the 1957 Act. And what the House of Lords determined was that it was the reckless act of diving that was the dangerous event, and not and that there wasn't danger as a result of the premises themselves. So the shallow water, it wasn't the danger, it was the diving into the shallow water that was the dangerous act. And the reason for that is that otherwise any premises can be said to be dangerous by someone who chooses to use them for some dangerous activity. The other example case I've got, which deals with the question between state premises versus the activities done on them, is an example of where it goes to the activities done on them, which is a case of Gwilliam and West Hertfordshire Hospital NHS Trust, which is a Court of Appeal case in 2002, so before Tomlinson. And in that case, the claimant was a visitor to a fairground on hospital grounds. And one of the attractions was what was described as a splat wall, which was organised by an employee of the hospital, but arranged through an independent contractor. And we're going to come on to this case later when we talk about independent contractors. Anyway, the claimant was injured due to the fact that the splat wall was not properly assembled. What the Court of Appeal said, it was an inherently risky activity that the claimant was undertaking. But different to Tomlinson, obviously they didn't have in mind Tomlinson, but there is a difference here to Tomlinson, because the claimant had actually been invited by the hospital to be there for the very purposes during which she was injured. So she was invited to effectively go on the splat wall and feature. And the hospital was then held to be in breach of their duty because they were occupiers. And the reason I talk about independent contractors is because we'll come on later to whether or not they were successful in effectively putting the blame on the independent contractors wholly or not. Anyway, those are just two examples of cases where you're looking at whether or not it's the state of the premises or whether it's activities that are being done on them that really is the trigger for a breach of duty. In terms of the standard of care to adopt, in Edwards and London Borough of Sutton, you were dealing with a case there, just by a brief reminder for everybody what the facts of that case were. Edwards was a case where there was a footbridge which had very low parapets, and the claimant was injured whilst pushing a bicycle and fell off the bridge, sustaining nasty injuries. The Court of Appeal in that case held that it was necessary to identify what the danger was before one can see what, if anything, the occupier's duty in each case attaches. The Court of Appeal accepted that the bridge had objectively a danger arising from the state of the premises, namely the lack of guardrails. But they went on to say that no liability would attach because, and this is where we pick up from the slide, there's no duty, this is what the two principles that were identified. There's no duty to guard against risks which are foreseeable but which are very unlikely to materialize, even if the consequences of the risk materializing would be very serious. And in reaching that, or setting out that principle, they referred to Bolton and Stone, which you'll all know is the case of the cricket ball going over the fence and injuring the claimant. And the second principle that Edwards referred to was the fact that occupiers of land are not under a duty to protect or even to warn against obvious dangers. And that principle comes from Tomlinson itself. Now, in Tomlinson, what Lord Hoffman said in relation to the first of those principles, in relation to foreseeability, said, allied with the issue of foreseeability of likelihood of risk is the balance of risk, gravity of injury, cost, and social value. And this is what a lot of people will look to in terms of saying this is how, these are the factors we need to consider when looking at whether or not there's been a breach of duty and setting out what the standard of care is. Now, earlier I said that Tomlinson is a 1984 Act case. So this could, when reference to 57, be deemed to be obiter, but there's no concern because in Cook and Swansea City Council, the Court of Appeal in 2017 said, when considering section 2.2 of the Occupiers Liability Act 1957, what you need to do is balance four considerations. And these four considerations are all pulled from that quote of Lord Hoffman in Tomlinson. And these are the four that are on the slide. The likelihood that someone may be injured, the seriousness of the injury which may occur, the social value of the activity which gives rise to the risk, and the cost of preventative measures. So you need to balance those four factors up and then determine whether or not, or actually, this is what the judge will be balancing, those four factors up to determine whether or not there's been a breach of duty. In Cook itself, the claimant slipped and fell on ice in an unmanned car park, which had only a system of reactive gritting upon reports from members of the public. And so the defendant entirely relied on members of the public effectively saying the car park is icy, it needs gritting. Which some of you might think on first instance, and certainly as I did, that that may not be a reasonable system for keeping people safe in using of the car park. But as it is, the Court of Appeal disagreed with my initial view, which is, and they went on to say that there was no breach. And the reason for that was that the risk of ice in cold weather is an obvious danger. And they also went to say that people can expect to watch out, or it can be expected for people to watch out for ice and to take care. Other salient features in the case, which I haven't yet let you in on, is that there would be no previous reports of dangerous ice, be no previous reports of any accidents. And the Court of Appeal then meant that if this defendant had to grit all of their unmanned car parks because they had a number, it would mean a prohibition of use of those car parks by members of the public. And that would come with a considerable amount of inconvenience because people need to use car parks for obvious reasons. And then finally, the Court of Appeal said that the regular gritting would be a disproportionate and costly reaction to the risk of caused by people slipping on ice. So that's an interesting case for anybody who's got those kind of factual scenarios, and I'm sure a lot of you will have seen at some point a case involving somebody slipping on ice in a car park. Should just stress that that's not authority for saying that this system is always going to be fine. Obviously, it's fact sensitive, and a lot depends on costs, but also how many car parks they run, etc. Here we're looking at a council which clearly had a number of car parks and had a similar system for all of them. So that's a brief sort of outview of the standard, well, duty care and then the standard of care and whether or not it will be breached or not. The occupiers liability enshrines within it, within section 2.3, two considerations which need to be given specialist thought in terms of the first one being children and the second one being independent contractors. So in terms of children, what the Act says is that an occupier must be prepared for children to be less careful than adults. Now, one example of a children's case is, again, a pre-57 case, which is the case of Glasgow Corporation and Taylor, which was a case determined in the Court of Appeal in 1922. That case involved a 7-year-old who sadly died after eating poisonous berries, which were in a public park. The plants themselves were fenced off, but there were no notices warning that the berries were poisonous. And it was held that by the court that the defendant counsel were liable and salient features in that case were that the plants and the berries themselves didn't present an obvious danger because it wasn't obvious that they were poisonous. And so it was held that the council should have taken sufficient measures to draw attention to the concealed danger. They also noted in that case that an occupier who is aware that something on his land might act as an allurement to children, for example, berries that look tasty, should take greater care to prevent that risk from manifesting. And so that's an example of a case involving children eating a poisonous berry. In terms of how to look at children, it's a question of degree, depending on the age of the child through to adulthood. And it's not a sliding feature because, of course, with very, very young children, they'll have no sort of thought process, or they might not have any thought process for what they're doing, and they'll be just running into a risk. And in those situations, you would expect some form of parental responsibility to be a factor, such as actually occurred in the case of Ryan and Camden LBC, because in that case, the defence counsel were held not to be liable for burns caused to a baby who got stuck. There's a horrific case, got stuck against unlagged hot pipes, which got very hot. And if you obviously came into contact with them, you'd ordinarily move away, but this baby got stuck against the pipes and suffered very significant burns as a result. But in that case, the court said that they were not liable for that because it was obvious that somebody who would touch against it would have fallen away, and in that case, it was very unlikely to have happened. And so it was really the very unlikely event that occurred, and therefore there was no breach of there's no breach of common law duty, but of the occupier, of course, it predated the 1957 Act. So that's children. In terms of contractors, what the Act says at 2.3b is effectively that an occupier can expect a person in exercise of their calling that they will appreciate and guard against any special risks ordinarily incident to it, so far as the occupier leaves him free to do so. So, for example, an electrician electrocuted when checking wiring in a premises is unlikely to be able to bring a claim against the occupier for exposing him to unsafe wiring. Now, section 2.3b ought not to be confused with section 2.4b, which is concerned with situations where the danger is due to the independent contractor. Now, where it said that the danger is due to the independent contractor, then section 2.4b may well come into play. And that really deals with the independent contractor defence, so effectively saying a defendant occupier say, well, it's not my responsibility what took place. I entrusted it to a reasonably competent independent contractor, and therefore I'm not in breach of duty, and they are. And quite often this will be often used as a contribution claim argument as well. For the occupier to absolve themselves of any breach of duty under section 2.4b, there are a number of factors that need to be satisfied. In fact, there are 3 factors that need to be satisfied. I was wondering if I put it on the slide, but I haven't. What those are effectively are set out within the slide and within the 2.4b itself. So first of all, what the occupier has to prove is that it was reasonable to entrust work to the contractor in the first place. Now, the reason for that is it prevents occupiers just offloading everything to a contractor. So there may be examples where it wasn't reasonable to offload whatever was going on the premises to an independent contractor. And that would be a question of fact, of course. The second thing that the occupier needs to do is establish that he'd taken steps as he reasonably ought to have done to satisfy himself that the contractor was competent, and take such steps as he really ought to satisfy himself that the work itself has been done properly. So what does that mean in reality? Well, quite obviously what it means is that you need to check that the contractor is competent by performing background checks or reading reviews about them or checking qualifications or all of those things. And there'll be other examples of things that you should be doing or your client should be doing if you're for the defendant to make sure that they did suitable competency checks. And in terms of checking the work is done properly, depending on the size of the outfit or the individuals involved, an inspection afterwards may well be required. In fact, pretty much every case I would anticipate that if whoever's paid for the independent contractor to do certain works hasn't done any kind of inspection, then it might cause difficulty, unless of course it's something which can't be inspected reasonably. For example, if somebody who's fitted in to or boxed in electrical works or something of that nature, and in that stage I would suspect it is reasonable to not to have inspected the work itself, because it'd be difficult to do so. So the point really here is that if the occupier doesn't satisfy those three steps, and you can come fall foul from any one of them, then they may still be liable. And the example of Gwilliam, which I gave earlier, is one such example, because in that case, as discussed earlier, the claimant was injured using splat wool. The hospital remained liable because they hadn't done sufficient checks to check the competency of that independent contractor. Just now going to go on to warnings, because there's a special provision within the occupiers liability that specifically deals with warnings, and that's section 2.4a. And effectively what it says is that where damage is caused by a visitor by a danger of which he had been warned by the occupier, the warning is not to be treated without more as absolving the occupier from liability, unless in all the circumstances it was enough to enable the visitor to be reasonably safe. In terms of warnings, there are a number of features that have come through from the cases. Firstly, the first thing to point out is visitors shouldn't have to play guess the hazard whenever they see a warning. So it will need to be specific when there is a specific risk. So, for example, if a fence is electrocuted or electrified even, then the appropriate warning would be caution electric fence, not simply caution. So that's an example of where there's a specific hazard which needs to be specifically addressed. Hidden dangers will require greater attention to be drawn to them than dangers which aren't hidden. For example, the poor boy that ate the poisonous berries. Conversely, very obvious risks require no warning at all. So in Tomlinson, it was obvious danger in terms of diving into shallow water, meant that there was no requirement to warn. In Edwards, the bridge case, it was an obvious danger by the bridge. It was held that, again, there was no duty to warn. In Lewis and Wandsworth, London Borough Council, which is a 2020 case, it was held there that it was obvious that a cricket ball cricket was being played in Battersea Park, and it was held that it was obvious that people would be trying to hit the ball far. It would be obvious that they would be using a hard cricket ball. It was obvious that cricket itself was being played. And in those circumstances, the first instance decision was overruled, and it was held that there was no duty to warn the claimant of those features before she was struck in the eye, sustaining a nasty eye injury. And in what was said there is that the risks of balls being hit towards the path which the claimant was on was so evident that any warning should have been superfluous. So the key question in relation to warning signs is really, would it have likely prevented the injury that we're looking at? And also, would such a warning sign on its own have been enough to enable the visitor to be reasonably safe? And so that will obviously be a question of fact in every case, or those, I should say, will be questions of fact in every case. Moving on to the defence of Volenti. This was recently considered in the case of White Lion Hotel and James, which was a Court of Appeal case handed down earlier this year. Now, the defence of Volenti is maintained in Occupiers Liability Act 1987. So it is a defence if the occupier can establish that the claimant voluntarily accepted the risk. But it's not as straightforward as simply asserting that and then arguing it. And as I said, the role of Volenti has been considered recently in the case of White Lion Hotel and James. Now, the salient features of that case are that the claimant came back from a wedding which he'd been to stay in the hotel. The hotel room itself was very hot, and he'd been suffering from heat or feelings of heat leading up to the wedding. He and his traveling companion had a cigarette in a no-smoking room outside of the window, and then they both went to sleep. At some point, the claimant woke up, and for reasons not known to anyone, he went back to the window and fell out of it, falling to his death. In terms of the window itself, it was low, it was capable of being opened fully, and had no sash mechanism preventing someone going through it. Now, what the defendant argued in that case was that there was no duty to protect or warn against the obvious danger caused by the window, and that essentially the claimant was the author of his own misfortune. And what the Court of Appeal held was that, first of all, what you must do is consider if the duty of care, first of all, you have to consider the duty of care and if it's breached by reference to Section 1, Section 2.1 and Section 2.2. And if it is breached, it's only then that you go on to consider Section 2.5, because that's a defence to that breach of duty. What they then did in the judgment is they considered cases such as Tomlinson, Edwards, Cook, which I've all covered already, and a case called Geary, which is also relevant in terms of Volenti. And Lady Justice Davis, what she did, she held was that Section 2.5 is indistinguishable to common law defence of Volenti. So you can look, and she did indeed look, at other cases, common law cases, where Volenti was an issue. And one of those cases that she concerned was Nettleship and Weston, where it stated that Volenti had been severely limited as a result of contributory negligence no longer being a complete defence. And what was said there in Edwards is that for the defence to succeed, what the defendant has to show is that the claimant was fully aware of the relevant danger and the consequent risk. Now, the claimant wasn't held to be fully aware of the danger and the consequent risk in White Line, and so the defendant, the hotel company, were held liable. And one of the really key points in deciding that was that in White Line, the owner itself of the hotel wasn't or didn't appreciate the risk of someone falling through the window prior to the accident. And what the point was made by the Court of Appeal is it's very difficult in those circumstances to make a finding that the visitor should possess a greater knowledge of the risk than the occupier of the premises themselves. And that would be a considerable step to take, and one that they were unwilling to do so. Just whilst we're talking about this, it's worth noting that the previous cases of Tomlinson and Edwards considered the activity of the claimant in relation to whether or not there'd been a breach of duty itself, rather than whether or not there'd been a situation of Volenti non-fit injuria. And another point, of course, which I possibly should have mentioned earlier, is in White Lion Hotel, there was a defect in the premises itself, which was the fact that the window was dangerous. And so that defect was a defect in the premises, which didn't exist in Tomlinson, and it didn't exist in Edwards, and it didn't exist in Geary. So there wasn't a danger arising out of the premises, which did exist in the White Line. So whilst Volenti still exists as a potential defence, in my humble view, I suspect that it's not a defence that will succeed in many cases. But that doesn't mean that it won't, because it's still enshrined in the Occupiers Liability Act. And if somebody does voluntarily take on risks that they are well aware of, and the inherent dangers as a result, then you will, or you may well be able to establish the defence. So there we are. That's the Occupiers Liability Act 1957. You'll be glad to hear that we don't need to be so detailed in relation to the Occupiers Liability Act 1984, because a lot of the features are the same, and we'll go through those in due course. As we said at the outset, what the Occupiers Liability Act is dealing with is trespassers, such as this smiley chap and his companion, who were photographed by a train driver who had to stop his train because they were trespassing to take photographs of the train that had just been stopped. But anyway, that's not really pertinent to the law of Occupiers Liability Act. What is more pertinent is what I've got on the screen here. And as we've already just said, the 84 Act is enacted rules to determine whether any duty is owed by an occupier to persons other than visitors in respect of risk of injury suffered on the premises by reason of any danger due to the state of the premises or to things done or omitted to be done on them. So as we've already discussed, very similar to the starting point of the 57 Act. In terms of whether somebody's an occupier, that's exactly the same test as the 1957 Act. Premises, exactly the same test as the Occupiers Liability Act 1957. So really what's the question here is whether the duty is potentially owed, who the duty is potentially owed to. Really, it's anyone who's not being a visitor. And so that's really it, is anybody who's not a lawful visitor is when you'd come under the 84 Act. But whether the duty itself is owed is another matter. So whether the occupier owes the duty, that's another matter. And what you need to look for there is what's set out in section 1.3, which is that the duty is owed only if all three of these matters are satisfied. First of all, that the occupier is aware of the danger or has reasonable grounds to believe it exists. Secondly, that they know or have reasonable grounds to believe the other, that's the trespasser, is in vicinity of the danger or may come to be in vicinity of the danger. And the risk is one against which, in all the circumstances of the case, he may reasonably be expected to offer the other some protection. How is that all to be applied? Well, the first two limbs, from the face of it, are subjective. They're looking at what the defendant occupier knows or ought to know. And the third limb is objective. So the first two are sort of objectively subjective, and the third limb is just more simply objective. In Tomlinson, Lord Hoffman considered these three factors. And in relation to section 1.3a, he said the occupier must be aware of the danger or have reasonable grounds to believe it exists. So I'll just go back a slide. For this purpose, it's necessary to see what the relevant danger was. So you need to look at what the relevant danger is in question. And in Tomlinson, it was held that the risk of injury was by horseplay in the shallows. And what Lord Hoffman said was they accepted that the defendant knew about this risk, albeit that the chances of such an accident happening were very small. And so they satisfied the first limb, section 1.3a. It went on to say that section 1.3b would also follow, that's obviously knowledge or foresight of the presence of the trespasser. And he found that the defendant plainly knew that swimmers came to the lake, and so that the limb was satisfied. In relation to section 1.3c, which is the third one on the slide, and whether it was reasonable to expect protection, Lord Hoffman asked the following: was the risk one which the council might reasonably be expected to offer the claim some protection? Well, in doing that, he was effectively just asking the question that's set by section 1.3c. It was in answering this that he said the following, that the duty is to take such care as is reasonable in all the circumstances of the case to see that he does not suffer injury on the premises by reason of the danger concerned. So in answering section 1.3c, he actually went on to be considering section 1.4, and he went on to say that the question of what amounts to such care as in all the circumstances depends upon assessing those four factors we looked at. The likelihood someone's injured, the seriousness of the injury which may occur, the social value of the activity, and the risk and the cost of preventative measures. Those factors we looked at earlier, which were endorsed in the case of Cook. And so he went on to discuss those, and then determined that that the claimant would not have got over section 1.3c, the third limb that they need to do so to enable a duty to exist, which on the face of it does look like they're rather going to section 1.4 ahead of time, because you don't really need to be concerning yourself with section 1.4 and whether or not there's a breach of the duty and what the standard of care is. You don't need to be looking at what the standard of care is unless it's held that there's a duty in the first place. So there might be said to be some criticism for the fact that that wasn't the approach that was adopted. But of course, it was clearly just so enmeshed together that it was not possible in that case to really take it out. And if we just go back in time to this slide, you can see why that would be, because of course what's being asked is whether the risk is one against which in all the circumstances of the case he may reasonably be expected to offer some protection. So it's very similar to the standard of care, and if the standard of care is breached, then you can see somebody saying, well, actually section 1.3c would also be satisfied by the claimant. Perhaps it's best to look at some cases dealing with this. I've just done Tomlinson. In terms of Keown, this was a case where an 11-year-old child fell off a fire escape or fire exit. Now, in that case, it was held he didn't get over section 1.1 because the accident wasn't due to the state of the premises. But they went on to consider, albeit obiter, whether or not the claimant would have succeeded on section 1.3 limbs, A, B, and C. And the Court of Appeal said that they would have done. What he said in terms of 1.3c, which is the third limb, is my tentative obiter view is that it would not be reasonable to expect a National Health Service. Sorry, they got over A and B, but not C. So that slide element is wrong, I'm afraid. But what he said, my tentative view is that it would not be reasonable to expect a National Health Service Trust to offer protection from such a risk. If it had to offer protection from the risk of falling from a normal fire escape, it would presumably have to offer the same protection from falling from pipes, etc. And this seems to me to be going too far. And decided this on the basis that it would involve using money better spent on treating patients. It would involve fencing off the whole area, which coincidentally they did after the event, but that was due to the fact that there may have been some break-ins as well. But the whole point was that they didn't, the court was saying, by fencing it all off, they'd lose the amenity for the local people to effectively pass through the grounds and for children to do non-dangerous activities like play football, example. Another case is Bucket and Staffordshire CC, which is a 2015 case where a child fell through a skylight. This was a High Court case. The first instance decision was held that the claimant didn't succeed because they didn't get over section 1.1a again, because it wasn't due to the premises that the danger existed. But again, in obiter comments, Judge Main QC held that there was no breach of section 3a or b, but there wouldn't be in that case a breach of section 3c. He simply said that he didn't find the risk of the youth falling through the skylight was one against which the defendant, in all the circumstances, the case might reasonably be expected of protection. Didn't elaborate on that. And in fairness to him, he was answering a question by the defendant's counsel, effectively to ask him to give judgment on these factors, even though he didn't need to, because he'd already determined the case under section 1.1a. In terms of the duty, it's to take such care as is reasonable in all the circumstances of the case to see that he does not suffer injury on the premises by reason of the danger concerned. Now, Tomlinson is your case to go to for that. That's obviously a 1984 Act case, and so the four balancing acts, four matters of balancing acts would be something that you need to consider whether or not there has been breach of that duty. In terms of warnings, I'm just keeping one eye on the time because I know it's coming up to 5:30. In terms of warnings, that's enshrined as well, but slightly different terminology to 57, and that'll be fact sensitive. Whether or not the warning is sufficient to effectively mean there's no breach of the standard of care or the breach of duty. And Volenti, again, is also enshrined in 84. Volenti is going to be more relevant in 1984 cases, one would have thought, because if you're dealing with a trespasser, they may well be voluntarily accepting the risk involved. So in those cases, you're more likely to have a tribunal. The judge is more likely to be willing to accept that there's a form of Volenti there. So that is a fairly detailed view of the Occupiers Liability Acts 1984 and 1987. The last two slides, well, the last slide deals with section 6A and 6C, which deals with countryside rights of way. I'm not going to go into that in any detail because we're slightly running out of time, but just keep an eye on that feature, which was introduced by way of the Countryside Act cases. In terms of wrapping things up, that obviously concludes the presentation part of the webinar. The more eagle-eyed of you will notice that I didn't touch upon impact of contracts in either section 3 of Occupiers Liability Act 1957 or Unfair Contract Term Act, which is enshrined within the Occupiers Liability Act 1984, and effectively it made an amendment to that act, because I didn't feel like there was going to be sufficient time, which, as it turns out, I was correct in considering. So that could have been borne out. I'm now just going to have a quick look at the Q&A box. I see I do have a question. I see. So Stephen Robbs asked, in the Taylor and Glasgow case, were the plants indigenous and would that have made a difference? Well, I'm afraid to say, Stephen, that I don't know the answer to that, but I don't think it would have made a difference because the point in that case was that the defendant counsel knew that the berries were poisonous and didn't take sufficient steps to prevent the child from eating them, and especially where they were berries in such format that they looked edible, and their knowledge was such that they should have warned against it, and the parents weren't held to have that knowledge. So I can see where you're getting at, is whether or not people ought to know whether indigenous plants are poisonous or not. I don't know whether in that case they were, I'm afraid, but I suspect the answer wouldn't be that it doesn't make a difference to whether or not they should have done more in terms of warning, because that case obviously came down to whether or not they should have put up some form of warning sign to say that the berries themselves were poisonous. So hopefully that answers your question. I don't see any other questions, which is a relief for me, bearing in mind it's now just coming up to 5:30. So what I will do is I'll just say thank you very much for joining me. I hope that the talk has been of some assistance. I know that those of you who have signed up for it are entitled to get the video, but I wouldn't wish anybody to watch it twice. But if anybody is watching this as a taping, having not seen it, then I hope it has been of some assistance and answered any questions that you may otherwise have had. So what I'll do is I'll just say thank you very much and leave you there, and hope you all have a very good evening. Okay, thank you very much. Bye.